Question 531. Although not authorized to do so, Agent Andrew acts on behalf of seller Stan by showing Stan's home to a potential buyer. Later, after the buyer makes an offer, Stan approves of Andrew's action. This is an example of A. Rescission, B. Ratification, C. Implication, D. Covering up. Correct answer is B. Ratification. Rescission is the cancellation or termination of a contract, as if it never existed. This is not what happened here. Stan approved the action that led to the offer. Implication can refer to authority that is reasonably assumed based on the agent's position or past actions, but in this case, Andrew was explicitly not authorized initially. Ratification is the specific term for subsequent approval of unauthorized actions. Covering up implies concealing wrongdoing, which is not the scenario described. Stan openly approved Andrew's action. Ratification occurs when a principal, seller Stan, approves or accepts an act that was performed on their behalf by an agent, Agent Andrew, who did not have the authority to do so at the time the act was performed. By approving Andrew's unauthorized showing of the home after the fact, Stan is retroactively granting Andrew the authority for that action. By approving Andrew's unauthorized showing of the home after the fact, Stan is retroactively granting Andrew the authority for that action. Question 532. Jody leases a property from Sandy. Although Sandy takes Jody for a tour of the property, Sandy does not mention that a large sinkhole is located at the end of the lawn, which Sandy has covered up with a tarp but not filled in. A month later, Jody's friend Jamie is visiting the property and falls into the sinkhole, breaking his arm. When Jamie sues Sandy for negligence, Jamie will probably A. Lose, because Jamie should have known that piece of land covered by a tarp represented a danger. B. Lose, because Sandy owed a duty to warn Jody, the lessee, but did not owe it to a visitor. C. Win, because Jamie was owed a duty to warn from Sandy. D. Lose, because a month had passed since the lease commenced. Correct answer is C. Win, because Jamie was owed a duty to warn from Sandy. Landlords generally have a duty to warn tenants of latent, hidden, defects or dangerous conditions on the property that the landlord knows or should have known about and which are not obvious to the tenant. Sandy actively concealed the sinkhole with a tarp, indicating knowledge of the dangerous condition and an intent to hide it. It is foreseeable that a tenant would have guests visit the property. Therefore, Sandy's duty to warn Jody extends to Jody's invitees like Jamie. While a tarp might suggest something is underneath, it doesn't necessarily scream, hidden, dangerous sinkhole. The law generally doesn't expect guests to anticipate deliberately concealed hazards. The duty to warn falls on the landowner who knows of the danger. Question 533. An exculpatory clause will not insulate a broker from liability to the purchaser if it is A. Not approved by a judge, B. Not endorsed by a contract attorney, C. Against public policy, D. Regarding a property that is worth less than $1 million. Correct answer is C. Against public policy. An exculpatory clause is a provision in a contract that attempts to relieve one party, in this case, the broker, from liability for their own negligence or wrongful acts. While such clauses can sometimes be enforceable, they are generally not enforced if they are deemed to be against public policy. Courts often find exculpatory clauses against public policy in situations where 1. There is a significant disparity in bargaining power between the parties. 2. The service being provided is essential to the public. 3. The party seeking to be relieved of liability is engaged in a business of a type generally thought suitable for public regulation. 4. The exculpatory clause attempts to excuse liability for gross negligence, willful misconduct, or intentional torts. In the context of a real estate broker's duties to a purchaser, there are certain standards of care and legal obligations that are considered important for consumer protection. An exculpatory clause that attempts to completely shield the broker from liability for their own negligence in fulfilling these duties could be seen as undermining these protections and therefore against public policy. Question 534. A real estate agent is required to choose the kind of agency relationship she is working under. A. Before the close of escrow. B. When escrow is opened. C. As soon as practical. D. When either the buyer or seller asks the agent. Correct answer is C. As soon as practical. Waiting until the end of the transaction to disclose agency is far too late and would violate the agent's duty of disclosure. By this point, decisions have been made based on the presumed representation. While opening escrow is a significant step in the transaction, agency disclosure should occur much earlier. While an agent should certainly disclose their agency upon request, they are proactively required to disclose it even before being asked, at the earliest practical opportunity. Waiting for a question puts the onus on the client to understand agency relationships. Therefore, the requirement is for the agent to disclose their agency relationship as soon as practical in their dealings with potential buyers and sellers. Real estate agents have a legal and ethical obligation to disclose their agency relationship to all parties in a transaction as soon as practical. This means at the earliest possible opportunity when substantive contact is made with a potential buyer or seller. The goal is to ensure transparency and avoid any misunderstandings about whom the agent represents. This ensures all parties are informed about who the agent represents from the outset. Question 535. The kind of lease that sets an initial rental rate, with periodic increases built in, is called an A. Step-up lease. B. Escalator lease. C. Acceleration lease. D. Periodic lease. Correct answer is A. Step-up lease. An escalator lease also involves rent increases. But these increases are usually tied to external factors, such as changes in the Consumer Price Index, CPI, or increases in the landlord's operating expenses. They are not fixed in advance like in a step-up lease. Acceleration lease is not a standard type of lease in real estate. Acceleration clause typically refers to a provision in a loan or lease that allows the lender or landlord to demand the entire remaining balance due if the borrower or tenant defaults. A periodic lease, e.g., month-to-month, has a set rental rate for each period, but it automatically renews for successive periods until either party gives notice of termination. It doesn't necessarily have pre-scheduled increases built into the agreement. Step-up lease specifies an initial rental rate that will increase at predetermined intervals and by set amounts throughout the lease term. These increases are built into the lease agreement from the beginning. Question 536. An appraisal is considered accurate only. A. As of the date it is completed. B. During the year in which it is completed. C. Until a more qualified appraiser completes his analysis. D. Until the beginning of the next fiscal year. Correct answer is A. As of the date it is completed. An appraisal is an opinion of value based on the market conditions and information available to the appraiser at a specific point in time. Market conditions in real estate are dynamic and can change due to various economic, social, and political factors. Therefore, the appraiser's conclusion of value is only considered accurate for the date of the appraisal. Market values can fluctuate significantly within a year. An appraisal completed in January might not accurately reflect the market in December of the same year. While a more experienced or specialized appraiser might offer a different opinion of value, the accuracy of the original appraisal is still tied to the specific date it was performed, based on the information available then. A subsequent appraisal reflects the market conditions at its completion date. Question 537. The contract clause that typically sets a maximum amount an injured party can recover in case of a breach of that contract is called A. Rescission. B. Liquidated damages. C. Specific performance. D. Compensatory damages. Correct answer is B. Liquidated damages. Rescission is the cancellation of a contract, returning the parties to their pre-contractual positions. It doesn't involve setting a limit on damages for a breach. Specific performance is a legal remedy where a court orders the breaching party to fulfill the terms of the contract, rather than paying monetary damages. It's about enforcing the contract, not limiting the amount of recovery. Compensatory damages aim to compensate the injured party for the actual losses they suffered as a result of the breach. While they are a form of monetary recovery, they are determined based on the actual harm caused, not a preset maximum amount in the contract itself. Liquidated damages clause specifies in advance the amount of money one party will pay to the other in the event of a breach of the contract. It's an attempt by the parties to agree on a fair and reasonable compensation for potential losses that might be difficult to calculate precisely. The purpose is to provide certainty and avoid costly litigation over damage amounts. Question 538. A house with a roof that slopes on all four sides is called a hip roof, B. Gambrel roof, C. Cornerstone roof, D. Tudor roof. Correct answer is A. Hip roof. A gambrel roof has two slopes on each side, with a steeper slope at the bottom and a gentler slope at the top. Cornerstone roof isn't a term for a standard roof type. A cornerstone is a specific stone laid at the foundation of a building. Tudor roofs are often half-timbered, with exposed beams and a steeply pitched gable roof. They might have some diagonal elements, but not necessarily sloping on all four sides. Hip roof is the most common type of roof that slopes downward on all four sides from a central ridge. It comes to a peak at the top and doesn't have vertical walls at the ends. Question 539. According to the rules of community property, the consent of both spouses must be obtained for the following regarding such property, except A. Selling the property, B. Leasing the property for over a year, C. Listing the property on the MLS, D. Encumbering the property with a mortgage. Correct answer is C. Listing the property on the MLS. Community property laws, which are in effect in California and other states, generally require the consent of both spouses for significant transactions involving community real property. These significant transactions typically involve the transfer or encumbrance of the ownership interest itself. Selling community real property is a transfer of ownership and unequivocally requires the written consent of both spouses under community property laws. In California, and many other community property states, leasing community real property for a term exceeding 1 year is considered a significant encumbrance and requires the consent of both spouses. This is to protect the long-term interests in the property. Placing a mortgage on community real property creates a lien against the title and requires the consent of both spouses. This is because it affects both spouses' interests in the asset and could lead to its loss through foreclosure. Listing a property for sale or rent on the multiple listing service, MLS, is a preliminary step to marketing the property. While it signifies an intent to sell or lease, it does not, in itself, transfer or encumber the title. Therefore, the consent of both spouses is generally not legally required just to list the property. However, as a practical matter, obtaining both spouses' agreement to list is highly advisable to ensure cooperation in a smooth transaction later. Question 540. A 4-year first trust loan for $28,000 is arranged by a real estate broker. The maximum commission he can charge under the law is A. $2,000, B. $2,800, C. $4,000, D. There is no such commission limit, the broker can charge whatever he thinks is fair. Correct answer is B. $2,800. In California, real estate brokers who arrange loans secured by real property are subject to specific commission limits under the Real Property Loan Law, California Business and Professions Code Section 10240 et seq. These limits are based on the loan term and the loan amount. For first trust loans of 3 years or more, the maximum commission is 10% of the loan amount if the loan is under $30,000. For loans of less than 3 years, the maximum commission is 5%. Since this is a 4-year loan for $28,000, both fitting the first category, the maximum commission is indeed 10% of the loan amount. $28,000 times 0.10 equals $2,800.